Welcome, everybody, to this week's Matrexit discussion group call. This is episode number 7 for introduction to legal research. And Jeremy and I were just kind of chit-chatting here prior to the recording. You want to continue with what you were talking about, Jeremy? Maybe your audio is gone again. At least it is on my end. There's something I wanted to show people here this evening. Something I noticed on social media a while back. And let me just go grab it so I can bring that screen up because it's kind of humorous. Hopefully you can all see that okay. And it was captioned on social media. Somebody had gone to one of their AI browsers or whatever and had asked it to show Jesus flipping over tables in the temple. And this was the picture that AI came up with. And people commented on it saying, oh, is this sacrilegious? Oh, this is the BS AI does, da da da. And people don't understand AI is going to follow the wording, follow your sentence structure, exactly the way legal sentence structure is set out. That's one of the reasons why I notice a lot of people will read something and not comprehend it at all. And then they even write things themselves which are uncomprehendable. Is because they don't understand basic sentence structure. So in this photo, they asked AI to show Jesus flipping over tables in the temple. And of course, there he is in the temple, and Jesus is flipping over a table in the temple. Now, if what they were wanting to see was Jesus turning over tables in the temple, instead of saying Jesus flipping over tables in the temple, it should have said, instead of Jesus flipping tables over in the temple. Be the tables that were getting flipped over, not him that was flipping over. So, I mean, to me, that was just kind of humorous sentence structure things that people don't fully comprehend. And it makes a big difference. And there's a lot of things that sometimes people will ask in a motion or something like that, and they don't get the results that they want. And the reason why is because they don't comprehend basic sentence structure. And to me, this was just a perfect example of that. Are you back with us, Jeremy?
Yes, sir.
Okay. What did you think of that photo?
That's hilarious. Great example.
Yeah, I thought it was a perfect example. But yeah, it just shows, people don't understand. It's going to be assumed that you mean what you say and that you say what you mean. You know what I mean? But anyway, I don't. Did you want to continue with the conversation we were having prior to starting the recording?
Yeah,
As far as how people could make a difference.
I was kind of talking about a lot of this stuff that people are going through whenever they're dealing with issues that they find that maybe they believe that their local politics or local government or whatever might be encroaching on. And because of those things, the court's limited on what they can do about it. So the aspect of is if you really want to do something, you've kind of got to get involved in politics, and then you can get on like that judicial committee and work whatever kind of committee you're trying to get on. They have education committee, they have constitutional committee, they have pretty much a committee for quite a few different things. If you want to look at the platform of a party, you can always see what it says and see if you want to change any of those things for your state. Those are very huge things, but that's your biggest duty as a person, which is your sovereignty, is your civic duty. And that's where you can actually utilize your votes as a delegate inside of the party. And I'm not with the belief that, just voting by itself is going to save anything. No, I would never say that. I would say that the only way that you could actually get anything done is by being a delegate to represent your community at the state level. Try to make sure that you can sit on one of the committees and actually advocate for the people. You'll see that there'll be a lot of stuff that they're trying to sneak in that's like you would never let that stuff pass, but because the lack of people is so so blatantly obvious, they're winning over and over and over. And it's just sad because there's just so many people that don't know about the delegation process and they only vote.
Yeah, man, to me, voting, the only thing voting really accomplishes is that it shows your consent through your participation. It shows your consent to the system.
It really does in a lot of aspects, but when you get into the political primaries, right, there's always a delegation or a caucus that you can get involved in. And these caucuses are very interesting, man. You'll sit there and you'll see this platform for your state that you're in. And then the platform will say this or that or whatever it is that they're trying to focus on. And these are only the people that are active in what they want. Remember that. So if you're not active, it's probably not your stuff getting passed. Anyway, there's a lot of stuff that they'll try to sneak in underneath the people's eye. And like, I mean, we could probably got millions of examples we could come up with. But the reality of it is the only reason why they're winning is because people aren't going and implementing their civic duty, being able to use their mind and being able to use their voice in these committees and saying, hey, no, I don't like that. We're done with that. I mean, there's people that I've talked to that have complaints about CPS and all that kind of stuff. Why don't you create a different office? Why don't you go in and make it so it's more family oriented and it's actually more beneficial and it's independent from the government? I mean, those are too big of ideas for some people, but I think that they're simple ideas that people could use to go into their party and have things changed. You can also make it so that people have more stricter censure laws. You could make it a felony. I mean, whatever you want to do, you're the people. All you got to do is go agree on something. It's not like it's like oh my God, we can't do this. No, it's actually very easy. And you just show up and do it. It's just scary because a lot of people won't do it. They won't learn Robert's Rules of Order. They won't go do Toastmasters. And then when they go back into court and they learn all this stuff from the parliamentary procedure, all the court stuff's easy.
Yeah, I agree. And I think a lot of people scoff. For instance, you mentioned Toastmasters. People don't realize how useful some of the exercises with Toastmasters can be. It's not just a place where people go in and give talks or give speeches. It's a place where you're actually learning how to speak and how to convey your thoughts to people. I think if people were to listen to some of these episodes as compared to maybe 2 or 3 years ago with episodes that I was doing, back at that time, you would have heard a whole lot more ers and uhs and ums and that kind of thing. Yeah. And that's one of the things Toastmasters will kind of pull out of your language pattern.
Oh, yeah. I was surprised when I watched Trump do his first State of the Union speech, and he never said once. I was like, wow, that actually just happened right there. He didn't say once. That was pretty amazing. How long did he speak for? Like an hour and a half or something? That's pretty
right. And people don't realize that this is one of the things that is paid attention to, that is watched for, as far as showing how confident you are behind what you're talking about or not. They're going to listen for those little common things that somebody that is not that skilled or isn't that honed on the subject that they're talking about, they're going to be looking for those little things to pop up. I remember there was a girl I knew a few years ago she was going to be going into court. I think it was over something fairly minor, but she had a big lipstick tattoo, with the lips on her neck, everything pierced, other tattoos. And I told her, I says, I would really recommend to you that you probably want to go and pull out some of those earrings and all the different piercings that you have and get some cover up and kind of cover up the tats on the face and all that.
Right.
And she said, well, that's not the way it's supposed to be. They're not supposed to judge us by, and it's like, yeah, guess what? That's not how it works, though. You know?
Right. Somebody said the other day to me, man, it was almost pretty interesting. He actually was like what you were just speaking on right now. It was very, very profound. He said, you ever watched the movie Tombstone? I was like, yeah. And he was like, you ever seen, the guy Doc Holliday? I'm like, yeah. He's like, well, just imagine if he wasn't wearing a suit in that movie. Do you think that everybody would have took him seriously as Doc Holliday?
Yep.
He would have never been Doc Holliday, right? I was just like, oh, wow. I never thought about that. It just made me feel so like, wow, the things you overlook.
Well, another little example here, and you don't have to get a prescription or go to the optometrist or anything. You can go to a dollar store and get some zero level glasses and just get yourself, a pair of black frame glasses. And for some reason, people think that the people they are listening to are a lot more well studied or versed in what they're talking about if they're wearing glasses. I don't know why that is. There's been studies done on it. It's just a mental thing about mankind that glasses, for some reason, trigger something in your mind to make you think that the individual talking is learned in what they're talking about.
Oh yeah, I could see that too. But at the same time, just dressing good, making it so you look respectable, it demands respect. And it's kind of amazing how that works. And it's kind of like a subconscious thing. So if you come in and you're dressed nice and you're taking care of yourself and you're defending yourself, it gives a totally different vibe.
Hey, it's just like going on a first date. If you go out on a first date, I mean, you want to dress to the nines, right?
Yeah.
You want to make sure you don't have any lettuce in between your teeth.
Yep.
You want to be looking good. What are you supposed to say there? Oh, well, they're just supposed to like me for the way I am. Well, yeah, but you still want to dress the part. You still want to put on the best presentation as to who you see yourself as you possibly can.
Oh, exactly. It's not only that. You want to make sure to come in there with your little wagon and your whole court case file and everything that you've got. So it's all right there in front of you. So you don't miss a beat. You're going 200,000 miles an hour. Because sometimes what we overlook is we're not preparing for the hearing. We're preparing for our argument, but we're not preparing for the hearing. What do I need while I'm talking on this issue? Those are things that you need to think about as well. Just so you can move fast. You don't want to ever be like, hey, let me get 15 minutes and find this. That is so bad, especially if you only got a certain block of time.
Well, and these are things that, like I said, with a date, things that we try to do in our regular life. So why wouldn't you do it for a court setting as well?
Exactly.
I remember a job that I was at one time. There was a guy coming in to take an audition to be a casino dealer at the place I worked at. And the casino manager called him over and said, okay, I'm going to send you to such and such a table. He said, by the way, did you not bring like a dress shirt or something? He said, oh yeah, I brought a dress shirt. He reached in his fanny pack, pulls out the shirt, right? Little by little, all wrinkled up, looks like he had slept in it. I don't know, maybe he had even, I don't know. But he goes and he puts that on, and the casino manager just looked at him and said, you know what? That's okay. You don't need to audition. Go ahead and go home.
You didn't put anything into this. We're not going to put anything to you either, pretty much. Yeah.
Exactly. You are only going to be taken as seriously as it appears you are taking it. If you're not taking it seriously, why should they take you seriously?
Exactly. That's really the whole common sense of the whole matter. And these are all humans. And sometimes what you'll find is they might actually know some words that you don't know. So you have to kind of be able to and you have to understand what they're saying and move with them. And if you understand what they're saying and you can move with them, they start respecting you. And it comes to that point, but you've really got to work to get there.
Well, Jeremy, there's another edge to it as well, and I know you would agree with this, and that is that what you are ultimately trying to do is, I mean, it's just like your first date. It's just like auditioning for a job, whatever the case is. It's same thing. Is the main thing that you really want to get, that one edge that you want to get, is that you want the court to like you.
Oh,
You know, if they don't like you, they're not going to be on your side for very much at all, even if you're 100% right.
You're absolutely right about that. The aspect of it is to be respectful. I mean, use language like, not like, a lot of people want to curse or something like that. Why don't they just say, I respectfully disagree, or I respectfully dissent, or I respectfully agree, Your Honor. Use those words in a formal fashion and make it so it's not so adversarial when you're getting your argument, because right away, if you use that language, it doesn't put them on the defense right away. So they might actually hear what you have to say right after that.
Exactly. And, you know, it doesn't even matter if it's just you coming in there pro se or attorneys. They deal with the same exact thing. I heard an attorney one time, he was talking about the situation with the judge, and he threw in like a slang word into a sentence. And the judge stopped him and she said, excuse me, is that a legal term? And he apologized and had to go back and rephrase his entire sentence.
Yeah. I had somebody do that one time. I was in a hearing and I watched him. I didn't tell him to do this. He just did it. They were telling him to, if he wanted to go and proceed, he could go and go under oath right now. And he goes, is that a requirement? And they were like, no. And he was like, oh, okay. Well, I guess I don't have to. Can we proceed? Is he going under oath? It was kind of funny because he's pointing right at the prosecutor. You know, you're sitting here thinking about it. It's like, oh, wow. Yeah, this is not something that they're wanting to do right now. Of course not. So, boom, that went away. But it was just funny because he just asked the question.
I've got a question for you, Jeremy. There was a situation that I saw one time, and what had happened was an attorney objected to something that was being said in the courtroom, and the judge kind of stopped the attorney in the middle of the objection, and told the attorney, hold on a second. You do understand that nobody here has been sworn in, right? And he kind of stopped and thought. He's like, oh, yeah. And I immediately thought right there, I was like, wait a second. If none of these people have been sworn in, is any of this really even on the record? Is any of this court case even legitimate at all? Or are they just going to say that a judge made a ruling in a certain case? There was no discussion, anything like that to back it up, no testimony or anything to back it up. But they'll just see that this decision was made and they're going to rubber stamp it and go with it. I thought that was kind of curious.
I think that's kind of interesting. Somebody's just like probably trying to wing it over there or trying to pull a fast one, I would think, because from what I'm reading in the model penal codes for the professional code of conduct, they have some rules, man. And I think it's 8.4C in the model. And it's and then they also have other ones where they can't lie to the judge. And the dishonesty thing is a big one because that gets them all disbarred. But you have to catch them. And you have to actually prove that they lied about it. And if you've got that, it's really just a checkmate afterwards. But it's 8.4C is from the professional code of conduct across the country. And it's a model penal code. They have one for every state. So, I mean, literally, I just think there's a lot of people that aren't being pro se. And they're not calling these guys on this stuff because most of those guys aren't going to call anybody on this stuff because they're all working for the same gig.
So would you say then, I mean, because you wouldn't be able to come back and say that, oh, something that was said in the court was a lie or someone perjured themselves if they hadn't even been sworn in to start with. They had never even promised to tell the truth under penalty of perjury. So what could you do?
As a lawyer, a lawyer standing in his capacity, if he tells the judge, right, if he tells the judge a lie, right, This could be considered as false statement, and it could also be considered as evidence tampering because he's talking about evidence. You have to call him on it with the 8.4C. You have to write the complaint up and then file it with the Bar Association in order to get somebody to be held credible for that stuff. That whenever they do that, they cannot lie to the judge. It's in their rules.
Right. So an attorney that was there in the room, actually, if things weren't going the direction that they wanted them to move in, actually should have brought up that fact and said, well, Judge, said, I respectfully request that the court swear in this testimony.
Well, that right there would be a different angle. Usually, if you're going in and you're trying to impeach somebody, that's one thing. But if you're a lawyer, you're supposed to not bring anything that's a false statement or anything up like that into the court. So in reality of it is you could file sanctions on that lawyer. You could hold him in contempt. There's these rules for this, and you would just have to write those things up. The aspect of them coming in and speaking on record whenever they're going to swear in, that's a different thing completely. You've got all these rules that they're supposed to uphold. Good moral character, believe it or not, is actually a requirement of lawyers. Most people wouldn't even believe that. Good moral character is also a requirement for police officers. A lot of people wouldn't believe that. But the thing is it's actually really a requirement. And then they have these code of conduct that people are just not applying to their cases or not looking at or not. And they're asking all these lawyers to do it for them. And I just think it's you're the best person for your own case. You're the person that can deal with your own facts. You can probably hire a lawyer to assist you with some of your arguments. But I would say if you're going to try to do this stuff, you always want to investigate your own facts and your own evidence to see where you're at.
Right. That is in their canons of conduct, and which is easy to find. Anybody can go online and look up their canons for their conduct, and you can scroll down through them and maybe pick out one or two things or more, maybe, that they did not follow.
Yeah, you always
anything.
Oh, I'm sorry. Go ahead. I'm sorry. I didn't mean to.
No, you're fine. I was just going to say anything you can add to your case, the better.
Yeah, the standard of review is something that you probably want to do in the beginning of your arguments. Usually, I mean, read that stuff because the appellate court will review your stuff under certain circumstances. Usually, it's abuse of discretion or independent review or constitutional issues or de novo. Those are things that you're going to have to review to see if you can actually get your arguments into the appellate court. And if you didn't bring your stuff up before trial, don't even think that you're going to win on appeal. That's just ridiculous because they'll laugh at you. They'll be like, you didn't even bring this up before trial, so what are you doing? And I think a lot of people don't even realize that. And they just race to trial and they waive all their rights and they lock themselves in so many different ways. And it's so bad. You can make a traffic ticket turn into some seriously crazy stuff. I mean, we saw that Sandra Bland issue over there in Texas. We've seen quite a few different examples, but there's also good ways of doing it, and that's usually being somewhat respectful. Usually, it's good to be very valiant and vigilant on what's going on, but always be very respectful. But make sure that they understand that you're going to give up your rights either.
Right. You don't want to overlook anything. Like we said before, if it's not raised, it's waived and it can't be brought up again.
What was it that one attorney brought up that one time? He was saying whenever they were talking about pulling people over and they were saying, hey, it says that my driver's license is my light's out. And they're like, I want to search your car. And he was like, well, what are you going to investigate to find in my car that determines my lights out? I stopped the whole search idea. It was kind of interesting. I thought that was interesting how he just approached it like that and kind of ended the topic. But it was funny too at the same time because they don't have probable cause from a light to be able to do that. So it's just very interesting. And it's all language, of course, but it's the way you approach it.
Well, and there's a lot of other interesting nuances like that with, say, for instance, the traffic stop. I saw a situation one time where a gentleman was pulled over for, whether it was speeding, running a stop sign, whatever the case was. And so the officer wrote the ticket for him, gave him the ticket, and the officer was walking away. And as he was walking back to his vehicle and walking past the trunk of the car, he thought he smelled something. And he turned around and went back and said, now, this is a cause situation. There was a cause. The cause was served. The ticket was written. And he said to the driver, he said, I'd like to look in your trunk. And he did coerce the operator of the vehicle to go and open the trunk. And when the gentleman opened the trunk, of course, there was, I don't know, half a pound of weed in there or something like that. But his attorney ended up getting that thrown out of court because that was not part of the stop. This was a second action altogether. And so that got tossed.
It's also not a part of the plain view doctrine. There's this doctrine where if they can't see it, then they can't search for it. If they can see it, then they're in. And that's just the whole thing. A lot of people don't read the law, so they overlook that and they get themselves in all kinds of trouble too. There's food of the poisonous tree whenever they violate the law. Any evidence that they get from that isn't admissible, and it's underneath the exclusionary rule. And there's a lot of language, but it's the formulas, and you really want to study the formulas, and you get those from reading the cases. You're going to get a lot of them from reading the cases.
Yeah, I've seen situations where an officer would say, they think they smelled something in the vehicle, and one of the passengers would be like, well, what do you think you smell? Like, well, it smells like marijuana to me. And well, the passenger would be like, well, that's strange. To me, it smells like roses, because an odor is like, it's not something that is clear vision. You know what I mean? Cut and dried, you know what's going on. A smell is something that can be interpreted.
Yeah. Well, I thought was really interesting is there were some people in Texas that were getting pulled over quite a bit, and there was used like I guess they would say in their opinion that some of these police officers abusing their power, that would pull people over and they would run their dogs around their car, and just to do that, and then afterwards they would say that they could search their car and just ransack their vehicle. I was pulled over once and I was doing a whole bunch of research and I was on fire at the moment, and I had done that research on that, and I realized that if they did run a dog around their car, then you could say, okay, well, I guess you can go get an affidavit or go get a warrant from the judge then to search. And then they're all like, what? No, I don't have to do that. And I'm like, yeah, you do. That's funny though. And then they were getting all mad and stuff. But the reality of it is the dog going to write an affidavit for him? I mean, come on. It's hilarious. What are they doing?
Yeah, there's situations like that are pretty simple that they're not used to getting thrown into. But when they do, there's no wiggle room.
I know, right? It's like, come on, guys. What are you doing over here? You can't be just making stuff up as you go.
But the problem is the average man or woman isn't aware of these things. So when it does happen to them, they get blindsided. And, that's one of the reasons why I wanted to start up doing this introduction into legal research, is because, somebody might get a summons in the mail or a complaint in the mail, and they see it's from, whatever, Ninth Circuit Court if you're from California or whatever, and they freak out. And the reason why they freak out is because they haven't learned any of these basic things, these simple things that they should have been taught, even, in grade school and high school. And so they're naturally going to trip out on it. And the same thing, they get like a letter from the IRS. They're going to immediately trip out because they've never been taught any of the nuances around these laws and how stuff really works. And so I want to start up doing this. That way people have a little more confidence, and their freak out meter doesn't go off, when they get something in the mail or when they see those lights behind them. They can take a deep breath and be like, yeah, I got this. You know what I mean?
Yeah, like they could file a failure motion to dismiss for failure to state a claim, which relief can be granted motion real quick. A 12B6 them and just knock them right out because they read the rule and they know how to write the motion themselves. That would be nice, especially if you have common knowledge from the people.
I got a phone call from somebody actually today, that they had gotten a judgment back in 2004 that somebody wanted to like sue them, garnish their wages, da da da. And back in 2004, the judge had said, no, they don't have the income level for it. They don't qualify for garnishment, da da da. And the judge threw it out. Now we're looking at an action that happened 2019, which is what we're looking at 15 years later, where the court again, somebody came back and wanted to bring up that old situation all over again. And they went ahead and answered the complaint or whatever that was sent to them by the courts back in 2019. And I just kind of gritted my teeth. I was like, you shouldn't have done that. You know, they should have made them open up a brand new case all over again, because that case from 15 years ago was gone.
Yeah, that was res judicata.
Yep, res judicata. And people don't comprehend that. And even stop and think about, something as simple as, like statute of limitations or something like that. But that's even double jeopardy. Once, res judicata, once the case has been decided and it's over with, it's over with.
Absolutely.
If somebody wants to come back again to sue, they're going to have to find a new cause. They're going to have some additional information.
Well, sometimes there's like, you can do a motion for a new trial, offer new evidence, or if you have a reason for that you appealed and you brought something up in a lower court that wasn't actually dealt with on the appeal and you haven't appealed yet, I think there's a thing where you can waive the rules, but you have to have a good reason.
Yeah, it normally takes a pretty good reason for the courts to do that.
Well, what you do is you get to waive the rules so they'll hear your appeal. Is what I'm getting at. So the aspect of it is it's an angle that you can get past. Sometimes it's usually a 2-month period if they waive the rules for it. And say you're 30 days behind and you missed it, you really try to get it in. They usually will give you a 2-month leeway on top of the 30 days.
Yeah.
But you have to request it correctly.
Well, I think this has been a fun little chat tonight. I'll have some additional info and links in the notes below here on YouTube. And as always, coming up tomorrow or the next day in Introduction to Legal Research on the Facebook group, there will be the list of words there as well, definition words, as well as resources to look them up. And one of the things I'm also going to do, and maybe if you have something that you want to throw my way as well, Jeremy, you can do it, is one of the things I want to start adding to it is hopefully a short little video that covers a specific topic that maybe attorneys talk about behind the scenes, things that people really don't know about, just simple stuff that can be used in your favor.
Like cross-examinations, depositions, requests for admissions, interrogatories, all those type of stuff. Summary judgment, default judgment.
Yep.
Yeah, all those things. So counterclaim, cross-claim. Those are fun.
Yep, you got it. All right, Jeremy, thank you. And thanks everybody for being here. Some point coming up here in the future, I do want to cover the book Modern Money Mechanics. It was out of print for a number of years and has now been available again past, 3 years or so. So that's a book I recommend people look up because so many people don't know how money works at all. And it would make a big difference on how you handle things. And but that'll be on a future date. And so I guess until next week, thanks everybody. Thanks, Jeremy.
Be blessed. Have a great week.
Good night.